It would be clearly seen as an economic stimulus. It would clearly be seen as something that the economy could manage. The school system would not be in chaos. The healthcare system would not be in chaos. We would be able to plan for it, deal with it, and in fact, it would be just fine. And that's the way to think about immigration. That's the way to think about people coming from abroad into Nova Scotia or elsewhere in Canada. The systems we have in place will not be in chaos. The systems we have in place will be able to deal with it. Of course, it requires some thinking, because many of these people will not come here speaking one of the two official languages, although many of them will, too. It's not as if this can happen without thought. It helps to turn thought to it, but it's well within our capabilities. But it's exactly because it is well within our capabilities that we should be getting on with it. And before I turn to virtues beyond the economic, we can nonetheless round this out. I pointed out a minute ago that we have some unfilled job positions, and we can anticipate more to come. There are those studies out there. They do indicate this. There is something a little more evanescent, though, about the nature of immigrants. People who have the gumption to be able to pick themselves up from one part of the world and move themselves to another part of the world are exactly the kind of people who are likely to be able to succeed in their new homes. I want to testify to this. Frequently over the last few years, I have been asked by MISA, the Metro Immigrant Settlement Association, to come and speak to their classes. This is the main organization in Nova Scotia that helps new immigrants and refugees settle here. And several times this year, I've been asked by the Halifax Regional School Board to come and speak to their classes where they're offering courses in English as a second language. For all of these classes, I've been asked to come to speak about how government functions, particularly the provincial government, of course, but inevitably that kind of discussion leads into the function of the federal government and the function of municipal government, and from there, the discussion goes in many directions. Anyone who talks to a class will know this experience. What I have found invariably in those classes is a group of people who are bright, who are learning enormous amounts about their new country, who are mad keen to make a place for themselves and their families here in Nova Scotia. And I'll emphasize that last bit because they would like to stay in Nova Scotia if they could. And just to jump ahead and for the minister's benefit, I'll say that the factor that they identify as the biggest barrier is not having jobs available to them here. I'm sure the minister knows that. But these are amazing people. These are people who are clearly dynamic. These are people who will clearly be successful in their future lives. These are people who will do well by themselves and by their families, by their children, and the next generation. And in many ways, that's not a surprise. And although I characterized most of these people as people who came here voluntarily, there are a lot of them who didn't come here voluntarily, who didn't voluntarily leave their home countries. Many of them are refugees. That is to say, people who have had to leave their home countries because of war or internal strife of one sort or another. And there's no difference in terms of their determination to succeed. It is just hugely striking every time I go to one of these classes. We are extremely fortunate to have organizations like MISA or the Halifax Immigrant Learning Centre, which also, in association with MISA, offers very focused courses. The people that I have met there have come from all over the world. The people I have met there seem to come from dozens of nations. And this tells us something about ourselves in Nova Scotia that sometimes we forget. And this is not just the fact that anyone who is not an Aboriginal person has come from somewhere else. This is something else. Although this is something, of course, I participate in, and I imagine many here also participate in. I will say that my ancestors certainly were immigrants to Nova Scotia. On my father's side, his father came as a young man almost 100 years ago now and settled in Nova Scotia. On my mother's side, her grandparents came fully 100 years ago now and settled in Nova Scotia. But our ethnicity, which is in geographic terms from Eastern Europe and from Russia, and by religious persuasion, Jewish, is in fact already unusual in Nova Scotia. When Nova Scotia is compared with other parts of Canada, what is striking in terms of ethnicity is that so many of the people here came in their ancestry from the British Isles. That's clearly, overwhelmingly, the largest group. People from England, people from Scotland, people from Wales, people from Ireland. In addition to that, there is, of course, a significant Acadian population here. But beyond that, our scattering of ethnicity is very sparse. This is not the case now in Canada in many other provinces. It certainly isn't the case in the provinces that have the largest cities that are now attracting most of the immigrants. It's not the case in Ontario with Toronto. It's not the case in British Columbia with the Vancouver area. It's not the case in Alberta with Edmonton and Calgary. And it's not the case in Montreal, although Quebec, of course, as a province as a whole, does have one very large historical background for its residents, and that, of course, is French. My point is that not only has Nova Scotia been slow, but that the mixture of cultural backgrounds that immigration is going to bring to Nova Scotia should be very welcome. So the justification, of course, is not just economic. There is a cultural benefit that will be very good for life and society in Nova Scotia. And there will also be a benefit sheerly in terms of knowing what goes on in the rest of the world. Because the opportunity to learn more about what goes on in the rest of the world increases enormously when people come and are your neighbors, are our neighbors, and their background and some of their linkage is with other cultures and other places. There then becomes an immediacy that we all gain in being able to talk with people whose families, whose friends are still in another country, in another part of the world. It's more immediate, it's more personal, and it's a better way to learn than just watching on television or listening to radio or reading in the newspapers. So I say that the benefits are undoubted. I say that Nova Scotia will benefit enormously by increased immigration and retention of immigrants and refugees. Now, I've mentioned the target numbers. I want also to say that there's another problem with the strategy that's been adopted for Nova Scotia. And the other main problem is that it's entirely too economic. Although I readily grant and will argue that there is undoubtedly a very good economic benefit from immigrants and refugees, what we have in our strategy is an orientation towards the immigrant investor. Now, I've been receiving letters, as I think other members of the House probably have, from the agency that the government has contracted with in order to help the immigrant investors. I've been receiving letters telling me that so-and-so is settled in Halifax, Chebucto, and perhaps at some point I might get the chance to make their acquaintance and welcome them. And I'm going to be happy to do that. But the focus on immigrant investors is a little worrisome. It's fine if we can find people who have $100,000 to invest in a new business. But that is not the only measure of the ability of an immigrant or refugee to make a contribution to our society. There are people who, of course, came to this country as immigrants or refugees with not a penny, who have done just fine. We should keep in mind that focusing our efforts on this class of immigrant will ultimately do us a bit of a disservice. So I urge the minister responsible for this new Office of Immigration to think about broadening the approach. And as the minister well knows, there are models out there in other provinces that we could well emulate. The two provinces that seem to have taken the most active steps in order to move forward a provincial level agenda of effective immigration attraction and retention are Quebec and Manitoba. Quebec, of course, because it has decided, and decided years ago, decades ago, that it wanted to pursue, on what was normally a federal matter, an independent course, has long had a very large Department of Immigration Matters. They have a big bureaucracy, they have comprehensive programs, they have money put into it, they have large numbers of bureaucrats assigned to the function. It's well advanced. But essentially, they have displaced the federal government presence in Quebec over matters of immigration. I'm not suggesting we move in that direction or to that extent. Certainly, we should learn much from what Quebec has done in terms of the programs that they have. But really, our model should be Manitoba. Manitoba is much like Nova Scotia. It's about the same size population, about 1 million people. It has about the same kind of urban-rural split, has similar kinds of history, but it too has taken faster and more aggressive steps with respect to immigration. Within the Manitoba government, they have a bureaucracy of, I think, about 50 people who are dedicated to working on immigration matters. If they can have 50 people, and if they can have targets of about 10,000 people, we should be thinking in terms of those kinds of numbers as well. Now, I know that we don't jump immediately from 1,300 to 10,000. That's not going to happen in 1 year, but it can happen. Excuse me, Mr. Speaker. Yes.
Order. I wonder if the honourable member would allow for an introduction.
I would indeed, Mr. Speaker.
Thank you. I'd like to recognize the Honourable Minister of Agriculture and Fisheries.
Thank you, Mr. Speaker, and I thank the member opposite for allowing me the time to introduce a good friend of mine. Lauren D'Entremont is in the West Gallery. Lauren is a friend since childhood. We spent long hours playing outside, playing baseball, and doing all those great things. And I just want to give him the warm welcome of the House as he visits Province House.
Thank you. Recognize the honourable member for Halifax-Chebucto.
Mr. Deputy Speaker, thank you very much. Even though I don't expect the minister to move through his new Office of Immigration from 1,300 to 10,000 people within 12 months, I do urge him to think about the Manitoba model. We can learn a lot from that province and how they've approached this. They are benefiting from their program. They're not having regrets or second thoughts or concerns about it. They're moving ahead, and they seem to be very successful with it, and I think it's the kind of model that we could follow. Finally, I want to flag for the minister one particular problem that I have encountered in discussions with a number of new immigrants and refugees. Indeed, I was surprised to encounter this particular problem at the door during the 2003 election as well. And it's the problem of credentials and moving credentials and having them recognized when they've been earned in one part of the world, but not here. Now, I know the minister is alive to this issue. I know that this is an issue on which we've heard a lot recently. But I want to emphasize to the minister that this is not confined to healthcare. Although, of course, the problem of having credentials recognized for physicians and nurses and other kinds of healthcare professionals is a very pressing one because of some of the gaps in our needs to fill the existing healthcare system. That's not the extent of the problem. I've heard from people who have engineering qualifications. I've dealt with people who have teaching qualifications. I've talked with people who have dental qualifications. All of these people have encountered difficulty in having their education and their professional qualifications recognized here in our province. Now, that isn't something that I think the minister or the government can solve immediately on their own. Clearly, for certain professions that are generally self-regulating professions, law, medicine, for example, the issue of recognition of foreign credentials is something that has to be discussed between the department, between the minister's office, and those self-regulating professions. But the sooner those discussions start to take place, the better. Nor is this purely a Nova Scotia problem. Clearly, this is something on which coordination among the provinces would be desirable. Immigrants are moving not just to Nova Scotia, of course, as we've said, they're moving in too few numbers here. This problem is surely one on which the other provinces that have longer experience must have acquired some expertise. And I hope that the minister will take the lead and start talking with those provinces. I hope the minister will take the lead and start pushing those self-regulating bodies to talk with other self-regulating bodies around this country. And I hope the minister will also push the universities and community college system to start talking with their corresponding entities around the country to work out a system of recognition of foreign degrees as a preliminary to moving on towards qualifications. This is a complex undertaking, but it's an important one and has to form a central part of our immigration strategy. So, Mr. Speaker, as others have said, of course, we're happy to see this office created. We're certainly supportive of this bill. We're supportive of seeing a cabinet-level position. We're happy that the government is moving ahead at last on this very important issue. But we look forward to the minister taking hold of this new responsibility and giving it everything it deserves. Thank you very much, Mr. Speaker.
Thank you. I recognize the Honourable Minister of Tourism, Culture, Heritage and Health Promotions to close debate on Bill number 153.
Thank you very much, Mr. Speaker, and welcome to the Chair, Mr. Speaker. I want to thank my colleagues across the floor for their comments with respect to Bill number 153. Mr. Speaker, I'm sure we'll be hearing more in the next number of weeks with regards to immigration. And I certainly appreciate the fact, Mr. Speaker, that we have to do all we can to attract immigrants here, to retain them, to integrate them, and to deal with issues, be they professional credentials, be they helping to integrate them more into the community and finding new programs, English as a second language, Mr. Speaker, issues in our schools. So certainly I appreciate the comments of my colleagues. I look forward, Mr. Speaker, to further debate on this issue. And with that, I'll move second reading of Bill number 153, the Public Service Act, Mr. Speaker.
Thank you. The motion is for second reading on Bill number 153. Is the House ready for the question? Would all those in favour of the motion signify by saying aye? Contrary minded, nay. Motion is carried.
Bill number 153, an act to amend Chapter 376 of the Revised Statutes 1989, the Public Service Act, to establish the Office of Immigration.
I order this bill be referred to the Committee on Law Amendments and recognize the Government House Leader.
Mr. Speaker, would you please call Bill number 162, the Public Utilities Act?
Bill number 162, the Public Utilities Act. I recognize the Honourable Minister of Energy.
Yes, thank you very much, Mr. Speaker. It's my pleasure to rise to speak on second reading of Bill number 162, an act to amend the Public Utilities Act. Mr. Speaker, it is a great pleasure to bring this bill to the House, as it will give both government and the Nova Scotia Utility and Review Board the ability to appoint a consumer advocate for the board's utility rate hearings. The Act will increase consumer protection when changes to rules or rates are proposed for gas, electricity, or water utilities in the province. Mr. Speaker, we know that consumers don't always have the time, expertise, or finances necessary to intervene in these types of hearings. This Act will give utility customers and consumers that voice through the Consumer Advocate. The Consumer Advocate will make sure that rates and rules proposed for consumers are both fair and are balanced. This bill ensures the interests and concerns of Nova Scotians will be represented by an independent person or group with the expertise and ability to participate in these complex hearings. The board will also have the ability to hire a consumer advocate who has the skills and expertise and experience appropriate to the task at hand. As well, government may make regulations relative to the qualifications and experience of the consumer advocate. Bill 162 provides added measure to ensure that the consumer advocate selected each time has no conflict of interest with specific application being considered at that time. Mr. Speaker, this amendment is flexible and cost-effective. Appointments will only be done on an as-needed basis. This arrangement will also help keep expenses reasonable for applicants who will reimburse the board for the costs of the consumer advocate, like they already do now for other expenses associated with rate applications. And Mr. Speaker, we know that changes to rates for basic necessities like electricity can hit consumers hard, especially those on fixed or limited incomes. But rate hearings are complex affairs, requiring extensive legal and technical preparation. The consumer advocate appointed pursuant to this amendment would have these skills: the consumer advocate will ensure that the evidence that supports fairness will be heard. Mr. Speaker, I believe these new provisions to the Public Utilities Act will provide consumers with more protection, especially our residential ratepayers, and I commend them to all members for favorable consideration. Thank you, Mr. Speaker.
Thank you. I'll recognize the honourable member for Halifax Citadel. Halifax.
It is indeed Halifax Shabukto. Thank you, Mr. Speaker. Well, I'd like to thank the Minister for having had the courtesy to offer to myself and a member of our caucus staff an advance briefing about his intentions to bring forward a bill to amend the Public Utilities Act in this way. And I would also like to immediately say that we intend to vote in favour of this bill at second reading. Having identified these 2 points, I think that's all I can say that's complimentary, so I'll move on to the main body of my speech. I think we have to start by recognizing the context within which this bill comes forward, and there is both an immediate context and a larger context. The immediate context, of course, is that Nova Scotians have only recently had a very absorbing experience watching the Utility and Review Board grapple with the exorbitant claim for increased rates by Nova Scotia Power Incorporated. And in the recent round of hearings, the following thing occurred. Nova Scotia Power came in and they asked essentially for 14% increase for everyone's power rates, to be effective January 1st, 2005. And during the set of hearings, a number of the parties, who I have to say are the usual parties who often appear at the Utility and Review Board over this matter, and I'll tell you who they are because it gives a bit more detail and it's easier to understand. Who can go and participate in these hearings at the Nova Scotia Utility and Review Board, which are very formal hearings. This is our premier adjudicative administrative body. And it, on rates, holds formal hearings. It gives advance notice of the nature of the hearings. Expert evidence is filed in written form. Formal interveners can take up status. They have the opportunity to ask written questions. In this case of Nova Scotia Power, they have the opportunity to ask questions in writing in advance of the hearings of their experts. They can file written evidence of their own, including retaining experts. And then, of course, there's the public hearings themselves. Well, as you can see, it's already a very time-consuming business to be involved in, plus the material is voluminous. It's something of an area for experts. And here's who goes. Of course, the applicant utility goes and is represented by its legal counsel, by its executive officers, by its by various staff. And then usually, either individually or collectively, the very largest of electricity consumers, entities like the pulp and paper plants, are present at these hearings. Sometimes there are other big players in our economy who can come forward with their legal counsel and their experts to participate in day after day of these hearings. It should be clear that it's an expensive process, it's a long drawn-out process, that it's a game for experts. Sometimes public interest advocacy groups will come. I myself have represented the Ecology Action Centre at Utility and Review Board hearings with respect to Nova Scotia Power in years gone by. So sometimes entities like the Ecology Action Centre are present. Sometimes Dalhousie Legal Aid is present. They will frequently come in order to represent the interests or attempt to represent the interests of low-income customers of Nova Scotia Power. And there is another entity called the Electricity Consumers Association of Nova Scotia, which takes on a critical role with respect to Nova Scotia Power. But they too represent often the interests of commercial customers. Now that's who normally gets to participate in these hearings. And I have to tell you, I know that for organizations like the Ecology Action Centre and for Dalhousie Legal Aid, it's a strain on resources to try to participate in these hearings. Now, in the most recent set of hearings, some, but not all, of the parties before the board got together and talked with one another about the possibility of working out a settlement in the middle of the hearings. And the utility met with representatives of their largest customers, and they met with a couple of the other interveners, and they met with representatives of the government of Nova Scotia, and they worked out a tentative settlement. But you know, a hearing before the Nova Scotia Utility and Review Board is not like a private lawsuit in front of a court. If 2 people or 3 people are in court suing each other, and they decide to go sit in a room and settle their differences, and they come back to the court and they say, here it is, we've settled our differences, the judge will sign off on it, and that's it. Now, there may be a few lawsuits in particular branches of equity where that wouldn't be the case, but for the most part, in your typical lawsuit, that's exactly what can happen. But not at the Utility and Review Board. And the reason for that, of course, is that the board is performing a public function. The board's function is not to treat the matters in front of it as if it were a private lawsuit in which several individuals or several parties could get together and decide what the result is going to be. The board's function cannot thus be usurped. The board's function is to pass upon the application that has been made to it, bearing in mind a variety of factors, including what's best for the public. So that element of the public interest is for the board to determine. And the board looked around at this settlement proposal, which, by the way, was for about 8.7% rate increase instead of 14%. And they said, we have to be satisfied that this is in the public interest. And they looked at the parties who were in front of them. They looked at Nova Scotia Power. They looked at Dal Legal Aid. They looked at the large customers who were there. They looked at the Electricity Consumers Association of Nova Scotia. They looked at the evidence they had put in, and they said, you know what? We don't think the public interest here really is going to be satisfied unless we take an extra step. What we need to do is retain the expertise of someone who can talk to us now about this settlement document and tell us whether it's a good or a bad thing. So the board, on its own motion, went out and found a person they were prepared to designate as the consumer advocate for this set of hearings. They found a person who had extensive experience dealing with electrical utilities and rates in the United States, a lawyer, someone who came from New Hampshire, who had worked, in fact, as a member of a regulatory commission there for a number of years, and they asked her to speak to the board about the proposed settlement. Now, we all know the ending of the story. The board went away after having heard all of this evidence, deliberated for quite a long time, and then came with what they said was perhaps an acceptable rate increase, and lo and behold, it was 6.1%. I say good for the board. I say the board did a very good job in this instance. It's a long way from 6.1% on, I think, April 1st, from 14% or even 8.7% on January 1st. Good for the board. But I mention this context, this immediate context, because what the board did was they took this step of appointing a consumer advocate, which indeed is one of the steps this legislation now specifically seems to want to provide for. They did it already, and they did it because the usual participants in front of the board, in the board's view, perhaps weren't really able to represent in their view really the needs of the average range of customers of Nova Scotia Power on an important matter. Now that's a hard reality in our province. The hard reality is that we don't have a public interest advocacy association as exists in British Columbia and in Ontario. We do not have a dedicated, ongoing, arm's length, independent, non-profit entity whose function it is to represent the customer, the average customer, the residential customer, in such hearings. And what a pity it is that we don't have such an entity. It's the richer part of the country, BC and Ontario, that have been able to find members of the public, enough members of the public, who are prepared to make donations to this kind of entity, a public interest advocacy association, to get them established in BC and Ontario. And they represent the consumer with respect to electricity rates, with respect to gas rates. They represent the customer with respect to common carrier rates. They represent the customer with respect to water rates. They represent sometimes the general public on environmental issues. They sometimes represent human rights issues. But we don't have such an entity, really. We have a few very focused organizations. We have some environmental groups, of which the Ecology Action Centre is the main active one. And we have, in front of the UARB on occasion, Dalhousie Legal Aid, which, it should be said, has to take the resources of their lawyers and staff away from individual cases in order to dedicate them to dealing with these general issues. I certainly don't fault Dal Legal Aid for doing this. I admire them. They do a very good job, but they have very limited resources. The EAC has limited resources. And so I wonder, in addition to observing the fact that we've had this immediate experience here with the board appointing a consumer advocate, and I wonder, given that we don't have an independent organization that has emerged on its own historically in Nova Scotia, whether what is being proposed in this amendment to the Public Utilities Act is the most beneficial way to go. It's a matter of profound regret to me that we don't have an independent organization in Nova Scotia that has managed to found itself. It's a matter of regret that we really don't have the money out there, apparently, amongst potential donors in the general public who have been able to come forward and start a public interest advocacy association of the kind that exists in a couple of other provinces. If that had happened years ago, it would have accumulated expertise. Presumably it would have a small staff, it would have a location, it would have a library of resources. I think that such an entity would have been a preferable way to go. Now, I'm not suggesting that the government should have founded such an entity unless a definite way could have been found to make it completely arm's length. What I think the government might have thought about is whether there might have been some way in order to encourage the money to come forward for such an entity here. So this is really second best. It's second best primarily because what is contemplated is a one-off creation of instant expertise. What is contemplated is that the board itself, in a particular proceeding, may appoint a consumer advocate, or that the cabinet may direct the board to do so. Unless there is a history, unless there is an ongoing body of knowledge that reposes in one place with some continuity of the people involved, this will not be doing as good a job as it might otherwise. This immediately directs our attention to another aspect of how we're being offered second best, or not quite good enough. And this is because what the bill contemplates is only that a consumer advocate can be appointed once the Utility and Review Board has in front of it some kind of matter that it's scrutinizing. There's no ability on the part of a consumer advocate to exist beforehand and petition the board to have hearings on particular matters. There has to be some issue that's already in front of the board that triggers the possible creation of a consumer advocate. So this too brings out another form of the weakness of what it is that's being suggested to us. Now, I'm not going to parse every clause of this bill because we don't do that at second reading. But there are weaknesses in what it is that's being suggested to us here. And I hope that we recognize that although a power to participate in settlement agreements is being contemplated for the consumer advocate, I hope we recognize that the board itself is in the process of rewriting its own procedural rules with respect to hearings like the hearings it has with respect to utility rates. It's doing that at this very moment. And part of the rewrite is to look at the rules around settlement agreements. But will there be a consumer advocate to talk to the board about what ought to be in the rules, about settlement agreements, or about any other matters for the conduct of hearings? There won't be, because as contemplated by this bill, there is only a consumer advocate invented from time to time, perhaps by the board, or perhaps upon direction from the cabinet. So I think, given that the board has already done this, has already appointed a consumer advocate on one occasion, that giving statutory recognition to this power that it's already exercised is the least the government can do. Now, the least the government can do is, in fact, exactly what we've been getting from this government. The idea of a consumer advocate is something, it seems to me, that's been talked about on this side of the floor on several previous occasions. And in fact, those occasions stretch back a number of years. And mirabile dictu, here we have, in a minority government situation, the government deciding that something that the official opposition has been talking about might be suitable for legislation, although it's the least they can do here. There's an amazing parallel between what's happened in this particular instance and what's been the government agenda ever since the 2003 election, when it became a minority government instead of a majority government. Because I have to ask myself, would we be seeing legislation about a consumer advocate if there weren't a minority government? I don't think so. And this fits within a context of a record that I think is plain to see. Just think back to the 2003 election. Our party, the official opposition now, for the third time in a row, ran on a platform that included a few items I'd like to remind the honourable members of. Freeze university tuition fees, we said. Well, the government didn't freeze tuition fees, but they did negotiate an MOU for 3.9%. The least they could do. Would they have done this if they were a majority and hadn't been forced into a minority position? Matter for speculation. I have my opinion. I doubt it. Automobile insurance rates are a problem, we said. Create a public auto insurance company. Well, the government wasn't too interested in doing anything about it, but ultimately felt they had to roll back rates by 20%, just 5% higher than the third party had suggested. Would they have done anything about it? They weren't particularly interested in doing something about it. Their immediate reaction was, the marketplace will fix itself. Put more money into the school system, we said. Well, they've started to do it. Pay the health care costs of people who are in long-term care, we said, and do it immediately. Okay, they said, we'll do that. We were planning on doing it a few years from now, but we'll do it. So what's striking about this? What's striking about this, including this item, is that the government wouldn't have done any of these things if it hadn't been forced into a minority position, if it hadn't been pushed by an opposition that has ideas that are attractive to the population in Nova Scotia. So in a way, we can say, thank you to the government for moving ahead on our agenda. Thank you very much for adopting our ideas. Thank you for moving ahead on them, however imperfectly. But, of course, given the situation the government's in, it's the least they can do. And that's what we have. Yet another bill, but it's the least they can do. From their perspective, it's the most they ever want to do. So we look forward to seeing this particular bill and others modeled on our agenda come forward and move through the system where we hope to be able to continue to improve them. Thank you very much, Mr. Speaker.
Recognize the honourable member for Halifax Citadel.
Thank you, Mr. Speaker. I wish to rise on this bill and make 6 points. The first is that we intend to support this bill going forward to second reading. The second is that this is a, we would argue, modest step, certainly in the right direction. It reflects the board having taken on its own initiative the authority to appoint a consumer's advocate quite recently. This gives statutory authority to that, and we would suggest it's just following what one would consider to be regular common sense. Thirdly, we would remind the government that this is not just about a consumer's advocate taking a position with respect to rate hearings for power in power hearing cases. It's obvious that the authority of a consumer's advocate can stretch well beyond the simple question of whether or not rates are set at an appropriate level. This is clearly an initiative that could encompass a position being taken on a wider variety of issues. And in fact, I would encourage down the road for a consumer's advocate to take an active role in a wider variety of questions than just power rate hearings. Obviously, there are environmental issues that are at play with respect to a number of the hearings that would be coming before the Public Utilities Board. Fourthly, and this is more to the point of the purpose of this piece of legislation, these hearings before the Public Utilities Board are obviously, or under the Public Utilities Act, are obviously more sophisticated as time goes on. The expertise and the required in order to follow the evidence requires technical evidence to be known and examined and researched, and certainly for the cross-examination of any witnesses to be at a relatively well-researched level. In order to be persuasive to the board, the advocates for consumers need to understand the technicalities around this, the evidence that's being presented. We did see in these last circumstances with respect to the rate hearings that the big players got together, decided that it was best on their own initiative to strike a deal. I think it's noteworthy what a substantial difference there was, Mr. Speaker, between what was originally proposed by Nova Scotia Power and what the ultimate decision was of the Utilities and Review Board. There was an enormous gap with respect to the ultimate rates that were received. I would commend the board for showing the foresight to appoint a consumer's advocate in those particular circumstances. So it's obvious that having a consumer's advocate is an appropriate step in these circumstances. We need to encourage this more often, which brings me to my fifth point, and that is that I would encourage the board to take an activist orientation in exercising its discretion to appoint a consumer's advocate. There is a discretion not to appoint. I would suggest in these circumstances that should be, and some policy should be set up to ensure that that is only done in the rarest of circumstances where it's obvious that there isn't any substantial or reasonable consumer interest. In almost all circumstances, there is a consumer interest. My sixth and final point, Mr. Speaker, before I do an introduction in the gallery with the indulgence of the House, is that the legislation as it's presently written speaks only of consumers, and I would urge upon the minister and the government to examine carefully whether or not the language of just using the word consumers is appropriate, and whether we need to be clearer that this really speaks to residential consumers and the commercial consumers that are at play before this board are obviously players who are well represented. Residential consumers are the ones that the board was concerned with on this last occasion, and I would urge upon the government careful consideration of an amendment. It appears to be necessary to ensure that this applies to residential consumers and not a broader scope of people. So with that, Mr. Speaker, I conclude by saying that, again, we are supportive of this matter going on to second reading, and with the indulgence of the House, I would like to provide an introduction to a number of the deputy sheriffs who are in the court in the West Gallery at this time, Mr. Speaker, if that pleases Mr. Speaker.
Thank you on an introduction.
Thank you, Mr. Speaker. In the West Gallery, you'll recall that we have been visited by a number of people representing the sheriffs who have certainly a grievance with the government that we hope will be listened to. And I would ask at the conclusion of my introduction of them that they all please rise and receive a warm welcome from the members of the legislature. David Elliott, Tammy Robertson, Dieter Conrath, Greg McKay, Daniel Ray, Derek McKenzie, Les Borden, Brian Kelly, Kimberly Northrup, George Grant, and Alan Gravel. If they could please rise and receive a warm welcome from the House. Thank you, Mr. Speaker. Those are my remarks.
Indeed, a welcome to all our visitors in the gallery this evening. Thank you. I'll recognize the Honourable Minister of Energy to close debate on Bill number 162.
Yes, thank you, Mr. Speaker. I move a second reading of Bill 162.
The motion is for second reading on Bill 162. Is the House ready for the question? Would all those in favour please signify by saying aye. Contrary minded, nay. Motion is carried.
Bill 162, entitled An Act to Amend Chapter 380 of the Revised Statutes 1989, the Public Utilities Act.
The order of this bill to be referred to the Committee of Law Amendments. I'll recognize the Government House Leader.
Speaker, would you please call the order of business would you please call Bill number 165, the Education Act?
Bill number 165, the Education Act. I'll recognize the Honourable Minister of Education.
Well, thank you, Mr. Speaker. I'm pleased to rise this afternoon for second reading of Bill 165, an act to amend Chapter 1 of the Act of 1995-96, the Education Act. Mr. Speaker, the majority of the changes in this piece of legislation are housekeeping. For example, there were one or two spelling mistakes that needed correction, and spelling mistakes, Mr. Speaker, which I'm pleased to say were done by a previous government. In addition, we had to update the department's name. There are a number of places in the existing legislation where the department was referred to as the Department of Education and Culture, and thus it was necessary to amend the act and strike out the word culture. Mr. Speaker, make no mistake, the other amendments we introduced on Friday are very important and speak to our ongoing efforts to ensure our students are learning in a safe environment and that taxpayers' dollars are used wisely. One of the amendments, Mr. Speaker, will see a board member leave his or her seat if they are convicted of an offense carrying a maximum sentence of 5 years or more. And of course, anyone convicted of certain child-related offenses will also cease to be a board member. The 5-year time frame did cause us some concern. And the advice that we received was that 5 years would include most serious offenses. However, there are some child-related offenses below the 5-year limit, and that's why, Mr. Speaker, we are going one extra step and are preparing regulations. The child-related offenses will be listed in the regulations, which are currently or will be developed. The amendments are in addition to steps we've already taken to ensure the safety and protection of students. For example, we already have the Code of Conduct policy, the Child Abuse Registry, and criminal record checks for teachers and others. Mr. Speaker, on Friday, many members of the media asked us why we introduced this amendment. They asked if we were responding to a particular situation, and I'm pleased to say that this amendment is not in response to any particular situation. What it is, Mr. Speaker, is the Department of Education being proactive to prevent such an event to occur. We don't want to see any harm come to any of our students. And this amendment, together with many of the other initiatives underway, will help protect our students today and in the future. In addition, Mr. Speaker, we also introduced an amendment that will prohibit board members from working for a school board that they are sitting on and for 6 months after they leave the board. And the purpose here is, I think quite understandably, to avoid a conflict of interest. Mr. Speaker, we also introduced an amendment that generated quite a bit of discussion on Friday, and that is if a board member resigns, they will be barred from running in special elections called to replace them. Again, reporters asked if we were doing this in response to a particular situation, and the answer again is no. Once again, we did not want to wait for such an event to occur. We're being proactive. We don't want to spend tax dollars on an election that was only caused because someone could not make up their mind. Taxpayers' dollars are too precious in board business, is too important to be interrupted by a special election. Now, I also want to clarify in response to a question that was asked on Friday, if a person opts to run in a federal or a provincial election, do they have to resign? And the answer is no. I would expect that they would take a leave of absence. If they are then subsequently elected in either provincial or federal sphere, then they would be required to leave the school board. And I hope that is now clear, Mr. Speaker. Mr. Speaker, we are proud of these amendments. We are confident that they will strengthen the Education Act. And at the same time, if members of the public or others have questions or concern, I encourage them to attend law amendments and make their concerns and ideas known. Thank you.
Thank you. Recognize the honourable member for Timberley Prospect.
Thank you, Mr. Speaker. Mr. Speaker, I've been to numerous press conferences in my career, if you can say that we have a career in this line of business. And there's a few press conferences that on occasion have been confusing. I talked in advance to the minister about the changes and dutifully report to the Red Room to see what's going to transpire. And that press conference went on a track that I think only someone from Cape Canaveral, or is it Kennedy now, probably could follow. And here we were off on, and I could say it was a tangent, but I think it was a moonshot. Because suddenly we were talking about Wade Marshall and Doug Sparks and African Nova Scotian candidates. And the issue at hand, from what had originally been told to me by the minister, was there were some housekeeping things, and spell check had found out that the Liberals couldn't spell maintenance, but that's another issue. So I want to look at the fact that, aside from the fact that there were a number of not red herrings, but blue herrings in this case, if we look at what was actually happening at the news conference, let's look at some concerns that I'm sure are going to be brought forward to law amendments. And I'd just like to address them at this time. Amy Smith, the reporter for the Herald, one of the reporters from the Herald, asked the question that was in everybody's mind. Why? Why is this being brought forward now? Why has this become an issue now? Of what intent is this particular piece of legislation at this time, in the history of this House, with this education department? And the answers, we've heard them again as the minister replied to Ms. Smith during her questions during the press conference, and the minister has reassured us that for various reasons there's no one that they're looking at, there's no serious case that's out there that they're going to be dealing with, but that intent is there. But I guess the key thing is, and this is the bottom line, is the safety and health and protection of children under our care, whether they are school principals, school teachers, or school board members. Because school board members, of course, regularly, if they're doing their job, are in the schools. They're there when the kids are there. And under no circumstances can we have somebody associating with school children who have been criminally charged. The concern that I'll be looking forward to hear about at law amendments is, and I know that the legal minds have advised the minister, and I know that certain learned members of the law in my caucus have said to me, you know, whether it's 5 years or 2 years is something that we should be looking at when it comes to a criminal charge. But the thing that concerns me is that we have this comment, certain child-related offenses. Certain child-related offenses. And I'm, at a later time in debate, hopefully this evening, or certainly when it comes back onto the floor, I want you to know that the Minister of Justice has brought in an important piece of legislation that has my support, let me assure you. And it has my support based upon my previous career as a school principal. It has my support also based upon my father's career as a Dorchester Penitentiary guard for 25 long years. And I know those deputy sheriffs there understand that those men, in certain situations, are taking people into court that have been charged with certain child-related offenses. And it seems to me, whether it's 2 years and a day or whether it's 10 years, The last thing that we can have is people who have been charged with, quote, certain child-related offenses anywhere near a school board position, let alone in a classroom. That is something of real concern to me as an educator. It's a concern to me now as a legislator, and I understand that you've been given advice, Mr. Minister, on that particular 5-year cutoff. I can tell you that the members of my caucus, when we discussed this today at our caucus meeting, we feel uncomfortable with that 5 years. We believe, unless there are other reasons that can be brought to our attention over the next number of weeks, that it should be 2 years. Because after all, this is a very sensitive issue when it comes to the safety and when it comes to the protection of our children. But that, of course, will unfold with the passage of time as we go through law amendments and we look at the presentations that we're going to hear from that will be taking place in that very important tradition of this House. There is, however, another particular part of this legislation, and as you well know, Mr. Speaker, we're not allowed to go through, and we certainly are not going to do it clause by clause at this stage, but there is a real important part of legislation in here when we look at what I consider the conflict of interest clause. That someone who has been working for the board in some role, who resigns, retires, for whatever reason, has to step back for 6 months before they can then be brought back on some perhaps private contract. They can be brought back as some special assistant. And that particular clause is a concern for the members of this caucus. It's a concern because are we looking, and again, I've heard the minister answer the question from Ms. Smith when we looked at the press conference, and I've heard the minister again make his comments in here, that this particular clause is not designed out there to get any particular person. And I'm not sure whether I feel comfortable with this at this stage. You know, the only thing you got to do is when you talk about school boards and school board members is talk to straight regional board. And it's no reflection on the current administration. It's no reflection on what has happened subsequent to Jack Sullivan. But we well remember that name. Let me tell you, Jack Sullivan always hit the jackpot. And when we as school administrators looked and said, that's how you run a school board? Is that what should be allowed to happen? And let me tell you that that will be a topic that will be brought up when we look at this particular piece of legislation and when we look at that conflict of interest and how things unfold in school board, quote-unquote, politics. Jackpot Sullivan's, his name always comes back to haunt us. His name comes back to haunt us because we see what should not have happened, but what was allowed to happen, and what lessons did we learn from this whole experience because of how the Strait Regional Board continues to recover, and to their credit, have done so miraculously, not miraculously, have done so in a great fashion because of the hard work of the people there who've cleaned up that mess. But that is an issue that haunts me when I look back at how things were done at that time and how anything as outrageous as that particular event happened. And now we look that Mr. Sullivan remarkably has landed on his feet and, heaven forbid, has another job in another part of this country in a similar position. Well, let me tell you, life must be grand. Life must be grand. Because when we look at what we learned from that experience, I look at that particular clause and I say, maybe that's the Jack Sullivan footnote. I'm not saying there's a conspiracy involved, and I hope the minister doesn't take it the wrong way. But did we learn any lessons from the Jackpot Sullivan show? Well, I'll tell you what we learned. We learned if you want to make a quick stop at the Millionaire Gate, then you make sure you get well connected with the people on a particular board. You keep them in the dark. You feed them so much you know what, and you suddenly have board members that are mushrooms and board members who are not out there making real tough decisions. That concerns me, Mr. Speaker. That's the suspicion that I have. I hope that this is not the case here, where we are basically playing catch-up on what happened in a regrettable history of school boards in this province. Because let me tell you, That particular chapter in school board history in this province is something that we will not soon forget. We'll not soon forget because of the embarrassment, but we'll not soon forget because of the dollars that were so misappropriated and did not end up in the very hands that need them most, the children under the care of that board. I'm talking about an issue that's of some relevance because it's on people's minds. When you look at changes to the Education Act and you say to yourself, well, what does certain child-related offenses mean? Why do we have this particular clause in there about 6 months? Why are we so concerned about 2 years or 5 years as a criminal charge as opposed to 2 years? So you can tell, Mr. Speaker, at this stage, we have more questions than we have answers. And in the process of law amendments, of course, hopefully Nova Scotians will have the opportunity to ask the very same questions that I've asked of the process that we're going to go through. Because this particular Education Act and the changes are well-intentioned. They needed to be done, but the intent and the timing is still of some concern to the members of this caucus. And with those comments, I look forward to this bill going through to law amendments, at which time we'll hear from Nova Scotians, school board members, and other interested people in the education system in this province. Thank you.
Recognize the honourable member for Halifax Clayton Park.
Thank you very much, Mr. Speaker. It gives me great pleasure to rise and speak on Bill 165, an act to amend the Acts of 1995-96, the Education Act. And, I understand the Education Act is very large. It covers many, many things. And the minister has said this is primarily housekeeping. And I know that there are a number of things that have been just cleaned up in terms of small spelling or punctuation. But there's a few things here that are of importance to Nova Scotians, and I think we need to be able to understand fully what the intent was. I was a little concerned when the minister, in giving his bill briefing, was not really able to say what had precipitated the need for making some of these changes. I mean, generally when government wants to make a change in any act or amend something, it's because there's been a gap recognized or something missing. Maybe something has been found to be inadequate and it needs to be strengthened. Or something has happened, something has occurred that showed that there was a weakness in the current legislation. And I think it would be better if we all understood what exactly these amendments were intended to cover and why they were conceived at the Department of Education. I believe that we have a lot of very pressing issues, and I know that the government's been looking hard at the upcoming budget and other things that could be done in education. And if that's the case, I'm just, somewhat perplexed as to why we're moving on a few of these things right now. And some of them seem to be half measures. They don't seem to be going far enough if they are suggesting that change should be made. So, Mr. Speaker, just to go to a few of the specifics in this amendment that's before us, I notice they have, particularly the conflict of interest one. I'll start with that. That's Clause 2A, which provides that you can't be a member of the school board and also at the same time an employee of the school board. And further to that says that you can't become an employee for a further 6 months after you cease to be a member of the school board itself. One of the concerns that I have and has been raised in our caucus is that sometimes it's difficult to find people to run for office and to assume that role of a school board representative. And I think it is worth noting, in some of the elections that the members are acclaimed because there are no contests for those positions, and they pay, at most usually a pretty small honorarium for serving in a very important capacity of governance for these school boards, each one of which manages and is responsible for really tens of millions of dollars in each case. And so it's a very important position, and yet we have sometimes difficulty in getting people to come forward and to serve. And I was told in particular in our French school board that there's often acclamations or a shortage of candidates, and it's not uncommon for a teacher in the French school board to also be serving on that school board position. So I'd have to check what the current status is, but I don't think it's been uncommon in the past. And so I just raised the issue that we shouldn't be putting more hurdles in the way of people who do want to serve, and that in that case, if there is a shortage, we should be considering that as a particular case, and maybe there needs to be some amendment made to accommodate that. It's just, as I say, something that needs to be considered. Yeah, so that's one thing. I do understand the need to protect the school board, and there should be conflict of interest guidelines without a doubt. And you know, I'm thinking back to when I sat on city council. If there were any decisions that related to business or the employer of the city councillor, they would simply not be present for a vote being taken. And so there were strict guidelines about something that might be touching closer to you personally and how you could absent yourself from that decision-making process. And that might be the way that could be attended to. On the point of Clause 3, whether or not you can be a candidate if you've resigned your position, I think we've had some clarification now over the last day or two about what that really means. If a person chooses to run for office at a higher level at city council or municipally, provincially, and so on, I gather they can simply take a leave of absence. And if that's the case and they have not resigned their position, and if they were unsuccessful in their campaign and their bid for office, they could return to continue to support and serve as a member of a school board. And I think that's very important, because one of my concerns is that again, seeking good candidates for office, you have to recognize that people are offering them their names to go forward as a public service, to become a public servant and represent their area. And I think that in that case, we don't want to make it very difficult. And I talked specifically about women and whether there are barriers for women running in office. And I think the fact that if you had to completely resign your seat and have no assurance that you'd be able to come back to it if you were unsuccessful would be a big deterrent for women seeking higher office. And as the minister knows, we've had a number of initiatives to encourage more women to participate in government. We've had a nonpartisan campaign school sponsored by the Advisory Council on the Status of Women that was very successful. And there's a municipal initiative underway to get more women to run for office at the municipal level. And I can tell you that women don't take as many risks, perhaps, when it comes to political life. Maybe that's one reason why they don't offer their names as much. There could be a myriad of reasons, but I know that if you were asking for a woman to resign a position completely, there may be extra issues at hand there. And to then not allow them to run again, I think, for that position would be wrong. So I think we've clarified that won't prevent somebody from seeking higher office, and I think that that's the proper way it should be, because all of the legislation that we enact should be encouraging women to be more active in everything from agencies, boards, and commissions to elected office, and that, at all levels. So I think that the members of this House would support me in that intent, because I think that would make this House and other bodies of legislatures and councils a lot more, perhaps more representative of our community, let's put it that way. So I'm glad to see that impediment has been removed. On the issue of standards, I consider it standards for people that put their names forward in terms of whether or not they're fit to be candidates or deemed to have the right qualities. We get to the clause, I guess it's clause 9, that talks about child-related offenses, and clause 2B that talks about having been convicted of an indictable offense that's punishable by a period of imprisonment of a maximum of more than 5 years. Both of those things, and also refers there to the child-related offenses designated in the regulations, which I guess, the concern I have there is I'd like to see what exactly gets written into the regulations. It's really important that members of this House, when we're approving legislation like this or allowing it to move through, that we have a clear sense of what the regulations are going to spell out. And it would not be the first time that things have happened that are written into the regulations that surprise members of the opposition, where a certain spirit or intent has been agreed to and a bill moved forward, and the regulations can actually be very, they can take a U-turn. They can be quite different from what we've agreed to or understood. So, I'm always a little leery when everything just gets designated under the regulations, and I think what the minister's probably aiming for there is, again, increasing the standards and asking that people that have got these kind of offenses that they simply wouldn't be members of our school board. And think again about what an important position that is, the position of trust, a board of individuals who help guide and set the direction for hundreds and thousands of children in their area. And, to have somebody who's been convicted of any offense related to children, I think is a grave concern. And I think that we might want to consider whether or not that part should go further, because if it's simply saying if you're convicted during the time that you're sitting as a school board member, we haven't protected against people who might have previous convictions. And I think upon reflection that probably is quite possible to suggest that if you have any child-related conviction or offense that you've been convicted of, that you not be ever able to serve on a school board. I don't think that's unreasonable. I was wondering about the legality of that, but there are certainly many jobs that you can't take if you have, say, a crime involving money and you have stolen or misappropriated money. Then there are many jobs where you have to be bonded, and you're not able to be if you have a criminal conviction. So I think that it would be in a similar vein that you could ask for that to be a requirement of a school board member. And again, we talked about it with the minister in his bill briefing, and there will apparently be no check whatsoever on past criminal records or anything of that nature. So, this bill doesn't go to that extent then, and I guess what I'm suggesting is that we should reconsider and say, if it's good to say that you can't have a conviction while you're sitting in that office, then why would we have somebody who's previously had that kind of a conviction? I mean, parents and members of the broader public are very concerned if there's any kind of child-related offense. I don't think we'd ever feel very comfortable thinking that the people that are sitting and making decisions about our children and their education, and in fact people who are in trusted positions, those same people who can go freely into our schools, talking to our teachers, finding out, solving the problems about the schools, they have free access to the schools and to the children there. And I think that needs to be really considered if we're going to look at standards for that service, that we should consider any previous convictions as cause for not being fit to serve. So I think that needs to be looked at. And again, we've talked about the first, I'm talking specifically about child-related offenses, but the other one covers serious offenses when we're talking about any kind of offense where you could be imprisoned for 5 years or more. And I think that certainly that also requires, careful consideration. I would say that is a reasonable once again, a reasonable clause to include. My only question would be, what if they had a previous term of that, served a previous prison term for whatever crime? Should that not also be considered something that makes them unfit, perhaps, for office, in the school board particularly? And then it was mentioned to me that there are no similar requirements for service at school board, or not school boards, but at city councils and other offices that might be guided by the Municipal Government Act or perhaps the Elections Act. And I think that by the very nature of bringing this before us today, it might suggest that we should be looking at a couple of those other acts to really provide to the public an assurance of the quality and caliber of the people who are offering for office. And so I'd like to leave that as a suggestion, because I think we've really just scratched the surface by identifying the clause, which is 2B, identifying that if you're currently sitting as a school board member in something like this, you're convicted of some of these offenses, that you're no longer fit. That's just the tip of the iceberg, I think. And I think if we're going to set out standards, let's be more specific. Overall, as I say, that those are really the three key things: whether or not you can be a candidate, and the conflict of interest, and the part about criminal conviction during your term of office. The other clauses are pretty inoffensive, and perhaps they were needed for housekeeping. But I think the other three we've talked about go a little bit beyond housekeeping and suggest perhaps some broader revision be done to maybe to other acts that guide our standards for people who seek office. But with that said, I do look forward to the stakeholders who will come to law amendments. I know we'll hear from school board members and others that represent the interests of children in education. And I think that perhaps they may see other things within this legislation that need to be addressed. So I'm going to wait and hear as well from them. And with that, I will thank you very much, Mr. Speaker.
Thank you. I recognize the honourable member for Dartmouth East.
Thank you, Mr. Speaker. I would like to take just a very few moments today, Mr. Speaker, to speak on the Act 165. As the Minister mentioned in his words, this is a mixture of some housekeeping catch-up work and some name changes. He did mention one important fact, which is, I think, the overriding reason for this, is to improve our student safety in the school system. And although he is saying there's no particular reason that has spurred these changes on, I myself was an elected school board member, and the first time I saw this bill, actually, it makes me wonder if there really isn't something behind this which has instigated this. When I first saw it, I did actually, question that. This bill, I believe, is trying to look at some conflicts of interest that maybe the Minister of Education and his department feel maybe they're now or maybe they're in the future. It's leading down the path of, the issue of if you are a member of the school board, then you cannot be employed by the school board. And after 6 months of leaving that position, you would have to wait 6 months before you could be employed. So my question is, if you were an elected school board member and you left, you either didn't win the election or you resigned or what have you for whatever reason, and then 6 months later you came back in some kind of position on that school board, I have to wonder, what would be the difference 6 months later, 8 months later, a year later, 2 months? If there's a conflict going on there that somebody thinks is an on-towards thing is going on, what would really change if what's 6 months going to do? I mean, if there's somebody, on the board that is going to look at you in a different light, and there's something that shouldn't be going on is going on there, where's this 6 months thing leading to? So I just wonder, where did the 6 months come from? And what really does it have to do with this? The bill states that any member of the school board who is convicted of an offense punishable by a term of imprisonment of a maximum of more than 5 years. Well, again, where did the 5 year, where did the number 5 come from? I have to question that. I guess I'm just looking for more background information on how this bill was written and what kind of information came forward to sort of lead the Department of Education down this road to write this bill. So I question those types of things, Mr. Speaker. Like, why isn't it 2 years? Just really, why is it 5 years? Also, any member of school board who is convicted by a child-related offense designated under the regulations. Well, we don't have the regulations, so I don't really know what that is. So there again, that's a question that down the road, I guess we have to wait and see that. Anybody in our caucus definitely is going to be in support of anything that is put out there to further protect our children, whether they're in the school system or wherever they are, if they're playing sports or whatever, after school programs. Certainly we're not against that. But there's just something about this bill that gives me a funny feeling, and I don't know how to explain it. And I can't help that. I have a feeling about this. So I guess maybe some of my questions will be answered in law amendments, and to that end, I guess I'll just look forward to it moving to law amendments, and I will look forward to hearing from maybe some of the parents or school board members that come in can shed a light on really, maybe they've got some ideas on why this bill is here before us today. So, Mr. Speaker, I will thank you for listening to me.
I recognize the Honourable Minister of Education to close debate on Bill number 165.
Well, thank you, Mr. Speaker, and I would like to thank the members on the opposite side of the House. I'm not so sure if I thought for a minute I was back in that press conference or the bill briefing on Friday afternoon from some of the comments that were made. But anyway, I'm pleased that the parties have agreed that it should go on to law amendments and perhaps get some of their concerns. I do just want to say one thing with regard to the business of not being the proposal that you would not be able to run in a by-election which you have caused by resigning. And the intent of that was if somebody gets mad in a board meeting and says, I'm gone, and then about a week later has sober second thought and says, well, I'll just run the by-election and get reelected. That's the type of behavior that sort of protection for boards. Anyway, Mr. Speaker, with that bit of interpretation, I'm pleased to move second reading of Bill 165.
Motion is for second reading on Bill number 165. Is the House ready for the question? All those in favour, please signify by saying aye. Contrary, nay. Motion's carried.
Bill 165, titled an act to amend Chapter 1 of the Acts 1995-96, the Education Act.
Order the bill be referred to the Committee on Law Amendments. Recognize the Government House Leader.
Yes, Mr. Speaker, would you please call Bill number 147, the Youth Justice Act? It's adjourned debate.
Bill number 147, the Youth Justice Act. I'll recognize the honourable member for Sackville-Cobequid, and I'll check on that, your times.
Thank you, Mr. Speaker. I'm pleased to stand to continue debate on Bill 147. As I said earlier in some of my comments on this bill, that it's a very important bill. It's on the minds of many Nova Scotians and definitely on the minds of many of the people I represent in Sackville. I think with recent cases that we've seen in this province where there's a lot of media attention around it and definitely the loss of innocent lives when it came to a crime committed by a youth and several youths, Mr. Speaker, that it really drives the community to wonder what we can do to change this, Mr. Speaker, and what can a community do to, and what can a government do to hopefully try to change the ways that our youth commit these crimes and definitely change the sentencing. Because, Mr. Speaker, I think that's where a lot of the frustration with many Nova Scotians are, is to see and witness and hear about these cases that youth have committed crimes in our province, and some of these cases have been done by repeat offenders and youths that have been convicted several times on different criminal offenses, Mr. Speaker, that there's not a huge penalty incurred by these youth in our province. And I think that's really where the public has stood up over the last year or so and said that we really need to address this, and government needs to do and act on the concerns of the residents, especially here in Nova Scotia. But that also begs the question on what had driven this piece of legislation to come to the House, Mr. Speaker. I said many times before that as an elected official, and I hope as an opposition member and government members bring proactive pieces of legislation to the floor for good public policy, Mr. Speaker. But I'd have to say that this piece of legislation is more the opposite, in the other category of a reactive type of stance that the government needed to take because of the outcry from the public, Mr. Speaker. And the question that many of the residents have asked me about what we can do, we do need to stiffen the fines, and I'll say again that I do support what this piece of legislation entails, and the hopefully stiffer fines and stiffer sentences for especially youth who commit crimes with motor vehicles, Mr. Speaker, but especially repeat offenders. And I think that's the alarming thing, that a lot of people have come to me and said, how can we change this? What in our community can we do to try to avert or change the course of what youth do, especially when it comes to committing crimes, Mr. Speaker? And I know our caucus, many of the members of my caucus spoke previous to me about additional resources and the need for the government to fund resources for the community so that they can recognize youth at a young age. And I know the member from Eastern Passage, or Cole Harbour Eastern Passage, mentioned this the other day about, if we identify a youth at a young age that they may be, as they term, a problem child, that those groups and organizations, and especially the schools, Mr. Speaker, have the resources to hopefully divert that troubled child or troubled youth and hopefully rehabilitate them or educate them or try to get them on the right path again. And I definitely know that that's one of the concerns we have as a caucus, that we need to emphasize to the government that they need to put more resources into our schools, especially because I think that's an avenue where the teachers, and if you had more teachers' assistants and youth support workers in every school or in an area of a school board, Mr. Mr. Speaker, that if you could identify these young children at a young age that, these people need extra resources, and hopefully give them the support, the community, the schools, and definitely the organizations that help youth and youth programs that they deliver in the province, that's an avenue where government needs to improve. We need a commitment from the government to increase the resources that these schools have, increase the resources to some of the nonprofit organizations in our province that deal with youth and youth initiatives, such as Boys and Girls Clubs, Mr. Speaker. And I'm proud to share and associate myself with a member from Cape Breton Nova who spent many years working with youth and troubled youth to try to change their direction, Mr. Speaker, and hopefully I think he definitely has done a great job over the years with that, and I think he made a difference, and there's many organizations like that out there, Mr. Speaker, that are just trying to identify those kids that need the extra resources. They need help with trying to abide by the law, if you want to say. I know this bill pertains with youth justice and especially crimes with the use of motor vehicles. But these organizations are struggling every day just to keep their doors open, Mr. Speaker. And I think that's where we need this government to commit to hopefully helping these organizations, these groups, these teachers, these counselors on doing their jobs to hopefully identify these kids. And as the member from Cole Harbour Eastern Passage said, if you don't catch them at an earlier age, a 5- and 6-year-old who may be a troubled youth, when they get 8, 9, 10, and get into the teen years, it's harder to try to make those youth understand that you have to act a certain way in society, and that there's consequences to their actions. And that's why definitely I know our members support a bill that increases somewhat the responsibility or the sentencing on these youth, especially repeat offenders. But it's more importantly that we need to get those resources out into the communities throughout our province, Mr. Speaker. I spoke a little bit on sport and recreation and the important need for government to fund different organizations in the province that go out into the communities and try to encourage youth to become involved in sports and recreation in their communities throughout the province, Mr. Speaker. Because definitely I think if you can keep youth active and a lot of mentors come out of coaches and being involved in team sports, Mr. Speaker, I think we really need to emphasize the fact that they're severely underfunded in this province, and we really need to look at hopefully government will look at increasing funding towards some of these sport and recreation organizations. I also mentioned the arts and culture sector too, Mr. Speaker, especially in our school systems. They seem to be the first target whenever there's a cuts made by government, provincially, federally, and even in the school boards, Mr. Speaker. It seems to be the first area that they go after. As I said before, not all students are involved in sports. Some may be into painting or writing or other artistic specialties, Mr. Speaker, and we really need to encourage that participation by the youth in the communities in the province, Mr. Speaker, to hopefully get the same effect as those mentors that I mentioned through sport and recreation, Mr. Speaker. And I believe that we need to fund these organizations and encourage school boards, and hopefully as a job of the opposition, encourage government to increase funding towards that aspect and those departments, especially in the school system, Mr. Speaker. One of the things I know that I like to do as the elected official in my area, Mr. Speaker, is get the input from the public and find out what their concerns are, what they would like to see, especially when it comes to legislation brought forward by the government, but future legislation, Mr. Speaker. And I would hope that the Minister of Justice took that into account when he brought this piece of legislation forward. I hope he went out and spoke with the community members, different communities throughout the province, to see what they would like to see in changing the Motor Vehicle Act or the Youth Justice Act. But most importantly, I would hope that the minister went out and sought the input of our youth, Mr. Speaker, in the community. Because I think when you deal with, especially a piece of legislation that affects the youth, I think they're the best resources we have, Mr. Speaker, in the province. That if we go out and ask them what would they like to see, they're involved. That maybe some of their schoolmates in class that have committed crimes in the past, and they may be the best experts we have, Mr. Speaker, on deciding what punishment we should have for individuals that commit crimes, especially youth that commit several crimes, and the punishment that the government should come down with. So if the minister hasn't went out and sought the input of some of our youth, I encourage him to go out and hopefully seek input, and maybe we might see some youth groups or youth may address this and certain clauses of this in law amendments. I do encourage any youth that are listening to this that, I encourage them to contact their MLAs and mention what they'd like to see in this, because I think that's an important aspect of maybe empowering our youth in our community to give them an opportunity to put input on a piece of legislation. We hear far too often that our youth feel like they're separate and that adults determine exactly what they need to do all the time and the consequences. And I think if we empower our youth in our community, especially when it comes to legislation that pertains to them, I think that's a great avenue to hopefully get great pieces of legislation through this floor or through the House, Mr. Speaker. So with that, Mr. Speaker, I encourage, like I say, the youth and the community to keep vocal, to keep in contact with their elected officials, to encourage them, especially the government, to increase the funding to the resources, to education, and especially to health, Mr. Speaker. Mental health in this province, I believe, is direly in need of additional resources, additional fundings, especially when we talk about youth mental health, Mr. Speaker. I mentioned it before about trying to help a family in my community that had a troubled youth, and we're trying every avenue, every program in this province to try to, rehabilitate their child, Mr. Speaker. And they were looking forward to the opening of the new secured treatment facility in Truro, Mr. Speaker. And sadly to say that, this family didn't get the resources it needed. It didn't get the help. It didn't get the work, I think, that needed to go into this young person because, Mr. Speaker, this young family actually is we're quite fed up with not getting that resources. That this young Nova Scotian is no longer in our province, Mr. Speaker. He's one of those numbers of individuals, number of youths that we had to send out of the province, Mr. Speaker. This province spends a lot of money sending our kids away to get rehabilitated or try a new program that might work, Mr. Speaker. And I think that truly is a shame. And it really was a shame to see that, here in this province, a family couldn't get the resources, couldn't get the help for their child, that now this child is no longer living in our province, Mr. Speaker. So I encourage government that they need to increase resources, increase funding to mental health, to the school boards, so that we can identify these kids in our community, and hopefully at a young age that we can hopefully give them the tools they need to make themselves productive resident in our communities, Mr. Speaker. And I look forward to this going to amendments. I know that there's a few other members that will stand and speak on this, but I truly hope that the Minister of Justice and the government is listening to some of the concerns of the community throughout this province. Thank you, Mr. Speaker.
Now, member for Cape Breton Nova. Mr. Speaker, I rise in my place today to speak about an issue that's important to me. I know this issue around Bill 147, an act to amend Chapter 38, the Acts of 2001, is to deal with young offenders joyriding in cars and problems today, Mr. Speaker, in society. But in order for, when I look at this piece of legislation, I think of the high-profile case and why this piece of legislation is here in the legislature today and how it arrived at that. So I would like to go back and look at what's going on with young people today, Mr. Speaker, and why, as myself as a youth worker, somebody that spent 15 years in the field of working with young people, whether it was in open custody and closed custody, whether it was in the youth center setting, to know and actually understand what's going on with young people today. Young people today who, Mr. Speaker, I think have great potential, Mr. Speaker, potential that I think we should have a look at instead of actually looking at what the problem is. What is the underlying problem with young people today? Why do young people make the decision to take a set of keys in an automobile and get in a high-speed chaser? What makes young people today do the things they do? Is there choices that they could have made? Sure there is, Mr. Speaker. There's good choices that they can make, but we as a society have to help these young people, Mr. Speaker, to make those choices. I listened to my colleague from Sackville, Cobequid. I listened to the members of the opposition speak on this bill. I listened to the government, Mr. Speaker. Long before I came to this legislature, I had the privilege to be on the board of directors of the YMCA, and I worked with my colleague, the minister, and the member from Cape Breton North on opening a camp in Barzwa many, many years ago. And that camp is still open today, and I credit the minister who would drive down to my house and pick me up when I didn't have an automobile and take me to those meetings and drive me out to camp, and we end up doing those things. So I think the member from Cape Breton North was quite involved with the YMCA movement, along with myself and other people. And after working in the field, as I was executive director and a youth worker,
That's right, you were.
youth worker, I guess, Mr. Speaker, when I first started in the field and I worked in closed custody, and when I was lights out at 9:30 and you put them in the cell at 9 o'clock, and I kept looking in there in those cells, and I kept saying to myself, is this what I want to do for the rest of my life? Is this what I'm here for? Is this why I went to Holland College? A graduate of Holland College like yourself that said, no, this is not what I'm supposed to do in my life, is to lock a young lad up and look at him and put my lights out at 9:30. There has to be something that I can do as a human being to help this young lad before he gets to that stage. And this is what I bring back to this legislation, this bill, Mr. Speaker. How can we stop these young people from making these decisions? How can we as legislators, how can we as a society, as we see what's going on today, the member from Cape Breton North tabled a petition with over 3,000 names on it for the youth crime and the vandalism that's going on in his neighborhood. Vandalism, poor decision making. I just think about, teen health centers, which we fought so hard to get for many years, in schools, in high schools, so to help these kids with their problems, Mr. Speaker. I think of going all the way up to Bay St. Lawrence at one time and looking at an old school up there to turn that into a youth center. I think of all the organizations that I worked with in the Family Place Resource Center. I think of the Community Cares in North Sydney. Recently sent a letter off to the Minister for Community Services supporting this organization for single mothers who are out there working and learning and getting employed and getting jobs, looking for this. It's a constant. I think today, what's wrong today, Mr. Speaker, is I think back as a young fella, and my colleague here from Cape Breton South was a Little League coach when I was growing up, and we had 3 Little League teams in the area of Whitney Pier. We had 3 Little League teams, and the member actually coached one of those teams from. No, he coached the Dodgers actually, and I played the other. Right? No, I'm not going to get into that right now in the ball, who won or who didn't, but I'm going to say that the member here volunteered his time, and many of us in the legislature volunteer times. But think of those 3 teams of Little League teams in that community at one time, and also a 4-team Midget B hockey league, a 5-team Midget B, a 5-team Midget basketball league. As I stand here today, there's none of those recreation sports left. I stand here and I listen to people debate about insurance for nonprofit organizations, insurance so that we can go to a school so I can volunteer my time to teach kids how to play basketball. I don't know where society is going, and I don't know where we're going as legislators, but what has come to us as legislatures is this bill. But I keep looking at the bill and I'm saying to myself, why did he pick up those keys? Is there anything that we can do as legislatures? And that's why I'm here today. I'm here today because I've seen it, mostly everything with young offenders. All the things I've seen, like, I think we have to empower youth. I think youth have to be a part of the solution. I don't think that we can say that, an example of building an $850,000 Boys and Girls Club on English Street in Sydney, and nobody showed up. They built $850,000 facility, and nobody showed up. We have to go to where the youth are. An example of the Dufferin Mall in Ontario. They were having problems with youth hanging out and causing problems and vandalism, so they decided to build a youth center in the mall itself. They alleviated the problem in the Dufferin Mall because the youth had somewhere to go. They actually had a place. They actually had a place where they could go and listen to music and do their own things and not have to worry about it. I'll give you an example of running a program. I started a program about 6 years ago called Midnight Basketball. Right. And I ran the program. It didn't start at midnight. It started at 10 o'clock in the evening, but it finished at midnight. So really, I was tricking the young people. They were playing 2 hours and running around and learning good decisions about being a team player. But when they were finished at 12 o'clock, they were that tired that they went home and got a shower. They went to bed. They didn't go down the road and do any vandalism. That's the kind of things that you did, and taught them that, you know, cognitive behave, like think before you do things. Think about before you try drugs and alcohol. Think about not picking up those car keys and going down the road at such a speed and having a terrible accident that we had here in the city. Think about making those good decisions. I think about one of the first young fellows that I worked with. I remember years ago in school when I was a kid, many years ago, young people were taken right out of school for bad behavior and taken right to Shelburne. Taken right out of school and taken right to Shelburne, no questions asked. So these young people were going up there and coming back to society, and the things that they learned and the things that they did. So we later decided that we were going to have what they call, you know, the restorative justice. So, and I know my colleague from Halifax Halifax Citadel worked very hard on the restorative justice program, because I was in that field for 10 years, and all the time that he spent, and all the time that the Ottawa and all the people in them said that we need to change this. We have to be able to have something where the whole idea of restorative justice is holding those young people and putting them to repair the harm that they've done caused by the conflict and the damage that they've done, to bring them in and hold them accountable. And I thought back as a young fellow, taking these kids to Shelburne. They had a 9-hour drive from Sydney to Shelburne. They had no contact with their family. They had no way to get a visit from their family. They had no contact with their siblings. But yet we as a society were shipping our kids off island to Shelburne. And all those behaviors and everything else, Mr. Speaker. I remember Father McFarland, the priest at Holy Redeemer Camp, going down to Shelburne and taking these young people out of Shelburne to take them back to Holy Redeemer Camp for the summer. That was something for somebody to do that. A Roman Catholic priest at the Holy Redeemer Church in Whitney Pier would go down and take those young people that were in trouble back to camp and try to help them. And I thought that's what I would like to do myself, and as a person, is to be able to give those young people a chance. That's all we ask for. So when they don't pick up those keys, or they don't make that choice with their peers to smoke, drink, you know what I mean? Young people that have connections to their community, Mr. Speaker, are young people that are less likely to be doing drinking and doing violence because if they're connected to their community. And I always, there's an old saying back, I guess, in the native culture, well, it takes a whole village to raise a child. Right. Well, it should take us as legislators a good hard look at what we're doing. We've turned nonprofit organizations into this province as beggars. Beggars. Nonprofit organizations come to the government. An example of the executive director, which the portfolio I held before I came here, had written to 3 different ministers in the government. Not this government, in the government before. And I wrote to 3 different ministers and saying to these ministers that, you know, the money that you spend now on prevention, is so much worth it. I mean, the little bit of money that you spend, so you give an operating grant. A lot of these nonprofit organizations and boys and girls clubs and other centers, they don't have the means, the core funding to keep open. They live from grant to grant. So you become a proposal writer. You become a funding and marketing person instead of actually being out there every day working with young people. That's what you become. You're a beggar. You're a beggar. And in society today, boys and girls clubs, youth clubs, Heartwood down in the valley, up in Bay St. Lawrence, Community Cares in North Sydney, the South End Community Centre in Sydney, Youth Centre in New Glasgow, and all these organizations have become beggars. When we're beggars are standing here in the legislature today and thinking about asking for money to provide programming for young people in the province of Nova Scotia. It doesn't make any sense to me. And young people who live in neighborhoods with plenty of community resources, such as parks, such as libraries and recreational areas and youth centers, you know, they develop better skills to make those decisions. But yet we, as legislators, are always struggling with the point when they come in and say, we'd like to have a skateboard park in a certain area. Well, in a skateboard park, we look at my age of being 50, a skateboard. Is that a sport? Today it is a sport. It's $1 million business. It's $1 billion business. And it is recreation. We have children today that are obese, but yet if they're on a skateboard or on a BMX bike and they're in a skateboard park and enjoying themselves, they wouldn't be out breaking windows or beating people up on the streets and rolling people, we used to say back then, and doing that to people. I mean, Mr. Speaker, we can't understand, and I've looked at this for many, many years, and I think to myself that of all the volunteers and all the people that spent in being involved in my life, as my coach in Little League, as my coach in hockey, as my coach in basketball, and my coach in, I look at my member from Cape Breton South who was a coach in Little League actually, and I go back to that again. But I mean, at least he was there. At least he was there putting his time in. But you ask people today, when you ask people to come to organizations and volunteer, and they're handed sheets of paper saying, okay, here's a document of confidentiality, here's a child abuse registry, here's a CPAC check. These people today are like, geez, you know, I'm afraid to volunteer with that organization because I have to do this, this, and this. Well, that's the way society is today. In order for us to put our trust in somebody working with children, that's why you don't see those people out there today. That's why you don't have those resources that were available back in the 60s and 70s, available today in the year 2005. Because we as a society, you know, have gone beyond, I guess, in looking at getting these people out to volunteer. You know, volunteers, nonprofit organizations. The insurance for nonprofit organizations. Example of the youth center I talked about in Whitney Pier. $2,240 for liability insurance. $895 a year for director of liability insurance. You're paying over $3,000 for the small little club that provides programming. And I'll say this, programming for young people free of charge. There's not one charge for any person that walks through the door of that facility.
That's the way it should be.
And it eliminates all the barriers. If there's a dance, everybody gets in. If there's weightlifting, everybody joins. There's taekwondo 3 nights a week, everybody's there.
Here, here.
And the community uses it 7 days a week. 7 days a week the people use that facility, free of charge. Do you know, when that facility opened, I remember I couldn't get any money from the government, and I kept pleading and asking at that time back in 1994. I actually had done a program on the CTV National News with a fellow by the name of Jim Nunson. And you know where he's at right now. So, I mean, I've done that program about youth at risk, and as I speak here today, I gave somewhat similar to the same sort of speech. And I had a phone call from somebody that said, I can't believe that you're running all these programs for that little bit of money, and you can't get any government help. Well, maybe I'd like to donate $50,000 to your organization. First of all, I thought it was one of my friends pulling my legs or something was going on, that I didn't believe this. This guy said, no, I want to give you $50,000 to run that facility until you can get her going. And I said, okay. Lo and behold, 2 weeks later, I get a check in a plain envelope on a scribbler page for $50,000. I thought I was dreaming or something. I took the check to the accountant at Grant Thornton and said, here is $50,000 check. And they said, no problem, it's good. And I was just like, really, this guy? But I mean, see again, the same amount of funding back in 1994 from the Minister of Community Services of $45,000. And I've written to ministers before him, the minister before him, and the minister before him. Oh, yeah. You know how much money that facility gets today? How much? $45,000. But yet we stand here and we look at this bill and we say, in this bill, that, you know, how do we stop that young person from picking up those keys? How do we stop him? Here's a facility that's out there providing these programs. Excuse me, Mr. Speaker. Providing these programs free of charge and looking at how do we get the government to realize that, you know, so in each letter that I wrote to previous ministers before him, and I guess I'll give credit where credit is due, if it wasn't for the Liberal leader back in 1995 at that time, and actually the Liberal MP who retired, and I think everybody in Halifax was trying to find out where he was doing with his pension when he retired from federal politics. Well, he was giving that pension to the Whitney Pier Youth Club. And that's what he was doing. And that's the truth, and he did. He gave me his pension. A nobleman. Here was an MP that later went on to become the leader and the premier of this province. Was giving me his pension for those kids at that facility. But yet I write this government and the government before this, and I say, here's $45,000. It's been 11 years with the same budget. The same thing going on, and we've had grant after grant. All these nonprofit organizations, whether it's Boys and Girls Clubs, the Whitney Pier Youth Club, the Glace Bay Police Boys Club, which my colleague from Glace Bay is involved in there, and all of these organizations keep looking for money to prevent this bill, Mr. Speaker, to prevent something like this from happening, to prevent this. So when we say to ourselves, why? We're not getting enough money. We're not getting enough money. We're not looking at that. A concentration of poverty in certain neighborhoods is growing. Why is it growing? Look at the areas. The member from Cape Breton North had a petition. The member from Halifax Needham, what's going on in different neighborhoods. The member from Dartmouth North. Why are these neighborhoods? What's going on in these neighborhoods, Mr. Speaker, that we as legislators should be looking at? We should be providing programs to these young people. We shouldn't worry about what colors they're wearing or what gangs they're in. We should not even, we have to be proactive as legislators. We have to. I'll give you an example in Ottawa. In Ottawa, the police in Ottawa said that they opened the neighborhood center. They opened the neighborhood center in a certain area of Ottawa. Within that center being open for 6 months, the crime rate in that neighborhood in Ottawa was down 60% from opening that youth center. The crime rate was down 60%. Then this is what we're talking about here today. The crime rate, and you could ask any police officer in the Cape Breton Region Municipality, the best place to have a shift right now is Whitney Pier. The reputation of Whitney Pier for anybody in this legislature for years and years and years has always been it's not a place to go, it's not a very good place, it's not a place to be. Well, I'm very proud to be from that neighborhood, Mr. Speaker, and I grew up on the streets of that neighborhood. And I have to tell you, Mr. Speaker, that it's a great place to grow up. I sit here and I represent the best of people. You know what I mean? When I met my wife, Mr. Speaker, and she's from the Miramichi in New Brunswick, and I met her, and I told her mother-in-law that I was from Whitney Pier. And her mother-in-law, and my mother-in-law said to her, but we were in Cape Breton in 1947 after the war. Your father-in-law was sent there to take down the gun batteries around the coast of Cape Breton. Yeah. And you lived in Sydney Mines. Yeah, well, the only place I wasn't allowed to go was Whitney Pier. I mean, this is my in-laws,
What'd you say about the Miramichi, though?
Well, the Miramichi is a great place to